Hi everybody, it's Andy, and welcome again to my office in Los Altos, California. I'm an attorney licensed to practice law in California as well as New York, and in this video I'm going to try to answer the question of why does it take so long and cost so much money to resolve a lawsuit that is so obviously frivolous? Um, Unfortunately, I think this question is not California specific. It's not New York specific. For better or worse, more worse if I'm honest, this question exists in every state in the United States. I mean, frivolous lawsuits just happen to be everywhere. So I'm willing to bet, and I have a sinking suspicion that I'm correct, that a lot of you who are watching this video probably found it because you are the defendant in a frivolous lawsuit of one kind or another. So some common ones that I've been involved in basically are, well, let's say that you're a defendant, you run a business, grocery store, hotel, restaurant, something like that, and you have no intention of hurting people. You're honest, you don't want to get sued, you try to do a good job, etc. But yet, one day somebody decides to sue you. A customer comes in, who is running a scam, let's say. They say that, your store was dangerous, they slipped and fell, and they want you to pay them $10 million. This person says that your store discriminates against women, discriminates against, the elderly, people with disabilities, etc. Now, you as the business owner, you know that you've done nothing wrong. But unfortunately, by the time it takes you to, prove all that, and, to basically prove that you've done nothing wrong, to prove that what is being alleged is untrue, you've had to spend $100,000 on lawyer fees. It's taken you 2 years that you could have spent doing other things, etc. So why is it that basically, if I've done nothing wrong, if I as the defendant have done nothing wrong, I still have to pay all this money? If you're in a situation like that, you would very logically wonder, why does it take the courts so long to determine that a lawsuit is frivolous? Shouldn't it be obvious? I can tell right away. So there are a couple ways to answer that question, basically. The one that I think makes the most sense to most people is basically this. If you ask a bunch of people to basically name why the United States is great, I'm sure you'll get a lot of different answers. Freedom, opportunity, hard work will get you ahead, etc. One of the things that I think a lot of people will mention is that the United States is great because in the eyes of the law, everybody is treated the same. In other countries, for example, like how the law treats you depends on how much money you have, depends on how much depends on which family you're from, and so on and so on. In the United States, it is, admittedly, at least in theory, not like that. It's the U.S. legal system is one in which even if you're poor, even if you're from the wrong social class or something, like you still get treated the same if you go to court. So by that logic, then if, for example, I'm sure as a defendant in a frivolous lawsuit, you would like nothing more than the judge to basically declare on the very first day, Mr. Plaintiff, your lawsuit is complete crap. I'm throwing it out. It's dismissed. The defendant is is entitled to their attorney's fees. The defendant is released from liability or something. I'm sure you as the defendant would like nothing more than the court to resolve that case right away. Unfortunately, though, I'm hoping you guys can see that if the judge does that, he or she is basically denying the plaintiff their right to have their case heard. I'm sure you've heard the phrase, in the U.S., everybody gets their day in court. So if the judge dismisses the plaintiff's case right away, the judge is basically denying the plaintiff his or her day in court. The right to have your day in court basically extends to everybody. Unfortunately, even those people with basically frivolous lawsuits. I will tell you that there are definitely people who take advantage of the everybody has their day in court thing, and they do definitely file frivolous lawsuits. But the reason why I guess it takes so long for the courts to resolve a frivolous lawsuit is that because everybody has their day in court and because the courts have to be impartial, the courts basically will do this. They're not going to make a judgment right at the beginning about whether or not this lawsuit is frivolous or not. They're going to say, or the courts are basically going to think, okay, we have a lawsuit that's been filed. A plaintiff has sued a defendant. This is what the plaintiff's alleged. Defendant has denied it. And what we're going to do now is we're going to tell the parties to go off and do discovery. Discovery, I don't have a video on that, but I'm sure you could Google a whole bunch about, discovery, like legal discovery. And, in a nutshell, discovery basically is the process in court by which, evidence is disclosed, information is exchanged. The courts generally like discovery because, the theory is that the more discovery happens, the more likely the parties are likely to settle the case, come to a compromise, etc. So what the courts generally are going to do in a civil case is, okay, defendant thinks that this case is frivolous. However, the courts cannot dismiss the case right away because in order to do that, it denies plaintiff their day in court. And what the courts will do is they'll say, okay, plaintiff, defendant, you guys go off and do discovery and, try and resolve the case. And once discovery is done, you guys can come back, or if you run into problems, you need to compel some stuff, have discovery motions, come back for that. But you guys go off and do your discovery stuff, and come back. Come back when you're done. Come back when you need something. So the idea is that during the course of discovery, plaintiff will basically have to put up or shut up. If plaintiff has alleged all these things that you as defendant know are not true, during discovery, you as defendant are entitled to have plaintiff produce all the evidence that substantiates the stuff that they're claiming. Maybe there is stuff that you're not aware of. Maybe there is not. Maybe there's nothing, I guess. Maybe plaintiff has no evidence at all. So this gets into a little bit more complicated of a discussion, but at the end of discovery, theoretically, plaintiff has produced all the evidence that shows why they have a case. Maybe plaintiff has done discovery on defendant too, who knows. But at the end of discovery, information has been exchanged, evidence has been disclosed. At that point, if you as the defendant believe that, the case is still frivolous and you want the judge to dismiss it then, summary judgment or something, maybe you can do that. But the idea basically is that whatever thing that you as the defendant in a frivolous lawsuit want the judge to do right away, dismiss the case, award attorney's fees, whatever, generally the courts are not going to do that right at the beginning because it denies the plaintiff their day in court. After discovery, however, if you as the defendant believe that there's still no evidence, that the case is still frivolous, for example, and you want to ask the judge to dismiss the case then, you can certainly try it. I don't know your case, but I don't know your law either. But, after discovery, I would say in general is a more appropriate time to ask for dismissal, summary judgment, that kind of thing. So hopefully all of that made sense. That's a little bit more kind of technical of an explanation than I was hoping to have to give, I guess. The basic idea is that, if you want to summarize it, defendants in a frivolous lawsuit obviously want the lawsuit dismissed right away because it's going to save time, save money, etc. Defendant won't have to pay lawyers to defend something that is basically frivolous. However, the courts are going to be reluctant to do that because in doing that, they're going to basically deny plaintiff, his or her day in court. And in the U.S., everybody has their day in court, or everybody's entitled to their day in court. So basically, if you're the defendant, you can't ask for dismissal or summary judgment or anything right away. You can do discovery. The courts almost certainly will make you do discovery, but at the end of discovery, if you still have or if you're still convinced that this case has no merit, it's frivolous, that you as defendant have done nothing wrong, are you going to ask for dismissal then? Are you going to ask for judgment on the pleadings? Are you going to ask for summary judgment? Ask for some type of relief then. I think that would be the more kind of preferred route. So think of it like discovery is basically something where you have to go through the hoops, and if you're right, discovery will just confirm what you already know. Plaintiff has no case, but the courts are not going to basically take your word for it. The plaintiff has no case. They're going to make everybody go through the process, I guess. So hopefully that helps. I will admit right now that it is not any consolation to you, I think, if you are the defendant in a frivolous lawsuit. But just kind of know that, one of the prices, I guess, of, being free in the United States is that everybody has, a right to have their day in court. And that basically means that a plaintiff has to be given the opportunity to prove whatever case they are making. So again, I will freely admit that's not a consolation if you're a defendant in a frivolous case, but that is basically how it is. That's how the court system views it. So anyway, hopefully all of that helped, made sense, etc. go ahead and comment, share, like, subscribe, etc. And I will talk to you guys next time. Thanks.